Welcome. Thank you for registering for our webinar, which we've entitled De Facto Breakups and Money. My name is Belinda and I'm an Associate Solicitor with Lynch Family Lawyers. It's 2 o'clock, so let's get underway. I'm mindful that your time is precious. Should you experience any audio or other technical difficulties during the webinar, please post in the panel and we will endeavour to fix. Unfortunately, there won't be an opportunity to ask any questions. However, I'll put up my contact details during the webinar and invite you to contact me if I can help you in some way. I will also be putting through some polling questions during the course of the webinar, and your participation would be much appreciated. Just helps to make it feel a little bit more interactive given we can't have questions today. So to start off with just a bit of an agenda about what I will be speaking about, I'm going to talk to you about who we are, who Michael Lynch Family Lawyers are, and talk to you about what is a de facto relationship, what is separation, and try and dispel that for you. Speak to you about some important time limits that you should be mindful of, and certainly telling your clients about, or suggesting that they speak to a lawyer if they haven't already, and also then speaking about spouse maintenance and property agreements. Who we are. Michael Lynch Family Lawyers is a specialist boutique family law firm. We've been established for 20 years. We have 9 lawyers. We have one of the most accredited specialists in Queensland, so that's a further qualification you can hold as a lawyer to be accredited in a specialist area. We represent clients in all facets relating to family law. We assist them with advice, negotiation, mediation, and court representation. Importantly, what we do is we offer a fixed price initial interview for clients. So they can come and speak with us for a fixed fee, provide them with advice, it's obligation free, and then they can make an informed decision about whether they do need a lawyer or whether now's the appropriate time to engage a lawyer. We do have some free books that we distribute, and we also have a free monthly e-newsletter. We present a number of public seminars and have regular articles that are available on our website. So I would encourage you to go onto our website and have a look at these items. And if you're wanting to sign up to receive our e-newsletter, if you're not already, you can certainly do so on our website as well. Who I am? Well, my name's Belinda Jeffrey, as I said. I'm admitted as a legal practitioner in the Supreme Court and also in the High Court of Australia. I'm an associate at Michael Lynch Family Lawyers. I also do volunteering at Women's Legal Service, and I'm a committee member on Women Lawyers Association of Queensland. I practice only in the area of family law and have done so now for at least the last 5 years. And I enjoy the area of family law and the service that we can provide to our clients, being a boutique law firm. Very much our approach at Michael Lynch Family Lawyers is to advise clients first and foremost, to arm them with the information that they need in order to make the best assessment of what they're wanting to do next. We then also can negotiate, we can mediate and attend mediations, and of course attend court and represent and litigate a matter at court. Different matters come to us and they require a multitude of those different areas, but that's really the approach that we take. Just a little bit of background. I think it's important to understand when I talk about the law in courts what I'm actually referring to. So the legislative provision is the Family Law Act in Australia, and it relates to all family law matters. It was enacted in 1975, so it's a relatively young legislation of just 42 years. The Family Law Act has a number of matters, so it includes divorce, parenting, property and financial settlements. It includes some areas about child support as well as surrogacy. Courts which exercise the jurisdiction in relation to family law are the Family Court of Australia and also the Federal Circuit Court. It was previously known as the Federal Magistrates Court. So the Family Law Act is a Commonwealth Act, which means that it's federal-based legislation. Let's launch into the main reason we've all logged into this webinar today, and that's to talk about de facto relationships and in terms of what is a de facto relationship. So to start with, a de facto relationship and the Family Law Act is covered for under that legislation. So there's two types of relationships that you can be, two types of committed relationships, I should say, that you can be in, married or de facto. Unlike a marriage, a de facto relationship cannot easily be verified. So with a marriage, you have a marriage certificate, and that's evidence that you're married. With a de facto relationship, it becomes a little bit more tricky. In November 2008, the Family Law Amendment, De Facto Financial Matters and Other Measures Act was given royal assent, and the most significant changes were about legislating for de facto property rights under the Family Law Act, and that came into force on the 1st of March 2009. De facto relationships between heterosexual and same-sex couples are now covered by this federal law and handled in almost the same way as married couples. So that's an important advancement that happened. This is all with the exception of Western Australia, where they've not conferred powers to the Commonwealth. So on the 1st of March 2009, all states and territories except for South Australia and Western Australia conferred the power. South Australia then later conferred their power to the Commonwealth, and that came into force on the 1st of July 2010. These are relevant when considering where a relationship has existed and, of course, the date of separation, and I'll talk a little about that later in the webinar. Primary objective for the amendments to the Family Law Act was to extend the financial settlement regime to parties in a de facto relationship, because prior to that they could only seek relief and not discretionary relief, maintenance or property adjustment orders through the state courts, so through state-based legislation. And here in Queensland, that was Part 19 of the Property Law Act. The Family Law Act contains a section setting out the definition and meaning of a de facto relationship, which is helpful when we're advising clients. The meaning of a de facto relationship is that a person is in a de facto relationship with another person if the persons are not legally married to each other, the persons are not related by family, and having regard to all the circumstances of their relationship, they have a relationship as a couple living together on a genuine domestic basis. The Act provides that a de facto relationship can exist between two persons of different sexes and between two persons of the same sex, so no longer is the Act limited to heterosexual couples. A de facto relationship can also exist if a party or a person to that relationship is legally married to someone else, or in fact even in another de facto relationship. I'm going to explore this a little bit further in my webinar. When the court is looking at and applying the Act as to whether there is a de facto relationship, it's necessary to establish when establishing that it's a de facto relationship, if it's been on a genuine domestic basis. So some of the factors that the court will consider to determine if two people have been living together on a genuine domestic basis include the duration of the relationship, the nature and extent of their common residence, whether a sexual relationship exists, the degree of financial dependence or interdependence, and any arrangements for financial support between them, the ownership, use and acquisition of their property, the degree of mutual commitment to a shared life, the care and support of a child or children, and the reputation and public aspects of their relationship. There must be a breakdown in the relationship for the court to then look at and assess whether there's a de facto relationship. Because until there is a breakdown in the relationship, the court doesn't have jurisdiction to deal with that de facto relationship. At this juncture, I wanted to ask the poll question: do you have clients who don't know if they're in a de facto relationship, possibly? Sometimes when considering if you're in a de facto relationship and looking at whether there's a genuine domestic relationship, you also need these gateway requirements. So they need to establish that the parties have been in a de facto relationship for at least 2 years. And this includes for same-sex couples, or that the total periods of the de facto relationship is at least 2 years. That there is a child of the relationship, or the party to the de facto relationship who applies for an order from the court has made a significant or substantial contribution to a kind mentioned in the Act. I'm just looking at the polling questions here, and if I've got that 80% have indicated, that around 80% have indicated that they do have clients who possibly don't realise they're in a de facto relationship, and that's certainly something that we're encountering when we're meeting with clients. Some deem their relationship to be a mere casual existence, or they see themselves more in a boyfriend-girlfriend relationship, or some even outrightly deny that they're in any sort of relationship. And certainly there's been a number of cases litigated before the courts that speak about when a relationship may exist or not. One such case that I'm thinking of at the moment involved a sex worker who made a claim for property order against a former client who she says was a partner of hers for 8 years. In that regard, the court did ultimately find that the parties had a relationship that exceeded friendship, but they didn't find the next step, that they had a relationship with financial interdependence, and that they were putting out to the greater public that their relationship was one of mutual commitment. But certainly in that regard, I think the key takeaway from that is that the court did find that they were in a relationship that was not just a mere friendship or a service and service provider relationship. This is always important for people to remember. Some other factors that the court will look at when considering if there is a de facto relationship under those gateway entries is whether a failure to make an order or a declaration would result in serious injustice to the person applying to the court, and whether the relationship was registered under a prescribed law, state or territory. It is the applicant, so it is the person who's seeking the declaration from the court or seeking property and financial settlement from the other party, who needs to prove the existence of a de facto relationship if it's not agreed. Of course, there are many circumstances out there where relationships are agreed, but it's just the fact that they may disagree about the period of the relationship or what assets exist in that relationship. So, for a bit of a summary, I did just want to clarify partners who separated, de facto partners who separated after 1 March 2009, except for South Australia, come under the Family Law Act. So since then, it's been legislated for under the Family Law Act. 1 July 2010 is when couples who separate in South Australia. There's 2 jurisdictional requirements. So one, you need to establish the breakdown of a de facto relationship, and secondly, that one of the 4 gateway requirements is met. There is an exception to this in that people are able to opt into the federal law even if their date of separation was prior to the 1st of March 2009. The choice must be unconditional between the parties and must satisfy the following conditions. Given the time that has passed now between March 2009 and the current date, it's unlikely that there's still going to be those couples who are needing to agitate for a property settlement. But if there were, they would need to both opt into that consideration. I've indicated some cases and I've put their citations up for your consideration, and I did just want to talk about a few of these cases. They're of interest as the courts had to consider in these cases whether there are relationships existent between the parties. So to talk to a few of the cases, the first one on my slide is Locke and Norton, which is a Family Court of Australia case decided in 2014. In that particular particular case, it was an application for a declaration regarding the existence of a de facto relationship by an applicant wife. The respondent denied that there was ever a de facto relationship. The applicant alleged that there was a 5-year relationship, although acknowledged and that they never lived together during that period. The respondent disputed that there was ever a relationship, so he was not even acknowledging the existence of the 5 years. The respondent in this matter was a man of considerable wealth and significant assets, whereas the applicant was unemployed. They had no children, and the applicant gave evidence that she stayed at the respondent's property each weekend when he was home in Sydney, typically a Friday night to Monday morning arrangement. It was acknowledged by the respondent that there was a sexual component, and the applicant says that there was a social component of their relationship. There was no jointly owned property, and there was no assertion that there was any financial interdependence between these parties. The respondent paid rent of $2,000 per month towards the applicant's accommodation, as well as a contribution towards her expenses, and this was something that changed over time. The court ultimately found that the applicant had not established on the balance of probabilities that the parties' relationships were a de facto relationship, and the fact that they did not have a common residence and no mutual commitment to a shared life satisfied the court on that balance of probabilities that their relationship was not a de facto case. Another case that I refer to is Millick and Lynch. Again, this is a 2014 case, and it was an application for property and financial settlement that was filed with the court. The parties were in a relationship of 11 months on the de facto husband's case, or 7 months on the de facto wife's case. They had no children of their relationship. However, the respondent wife had a child from a previous relationship who had some special needs, and that's relevant in this particular case. It was common ground between the parties that the relationship lasted less than 1 year. There were no children of their relationship, that the applicant made substantial contributions provided for in the Act, and that the relationship was not registered under prescribed law in any state or territory. The remaining question that presented it to the court was whether a failure to make an order would result in serious injustice to the applicant. So you'll recall when we went through the gateway requirements, one of the gateway requirements, and really a discretionary gateway requirement, was whether it would result in serious injustice to a party who was seeking for property or financial settlement. In this case, the principal asset of the parties was the former home, and it was registered in the sole name of the respondent husband. And although the parties were content to treat it as a joint asset, the judge determined it would be just and equitable to give the applicant a share of a value in that property. The respondent didn't dispute that, although what the respondent disputed was how much the applicant should receive. In this case, the respondent de facto wife's credibility was seriously undermined because during the relationship she continued to receive a means-tested Centrelink payment without notifying Centrelink that she was in a domestic relationship with the respondent. In this situation, the judge ultimately preferred the applicant's evidence in view of the wife's financial dishonesty and determined that the relationship lasted. It was further determined that it was going to be just and equitable to alter the parties' property interests because the parties' major asset being the real property, and gave a percentage and divided it in the respondent's favour, noting the respondent's greater initial direct financial contribution, but however the applicant's financial contribution and also having some entitlement in that regard. It's important when we speak with clients, we need to take a detailed history of the relationship and think about what's relevant in their particular situation. The level of detail that we get from clients when doing the initial appointment, we look at what contributions they did make and how they structured their relationship. And as you can see, this is quite important when we're considering if in fact there was a de facto relationship. And another case that I've mentioned is Benedict and Peake. In this particular case, the applicant, who was the de facto wife, alleged that there had been a de facto relationship of some 17 years. And the respondent, the de facto husband, said again, similar to the other cases, that there'd never been a relationship that could be categorised as a de facto relationship under the Act. And in the alternative, if it was found that the court did find that there had been a de facto relationship, that it ended before the de facto relationship provisions of the Family Law Act came into effect in 2009. And that's an important consideration in this matter. So the court needed to determine, firstly, if there was a de facto relationship, and secondly, if there was a de facto relationship, when did the parties end that relationship, and whether the court then had jurisdiction to deal with that matter. In this case, the judge determined that the parties had not been in a de facto relationship, at least not by the time the provisions of the Act came into effect, and therefore the court did not have jurisdiction to deal with their property settlement dispute. What still remained, though, was that the parties were jointly registered proprietors of a real property, and they would have to then commence proceedings in the state court in relation to severing their joint ownership and determining their respective interests in that property, that the provisions under the Family Law Act for any sort of maintenance or relief would not apply in this case. The last case that I'll talk to you about, because I'm mindful while lawyers find case summaries interesting, those not in the legal profession probably don't find them as interesting, is Wallace and Rankin. This is a 2015 case where, again, there was a de facto relationship contested by the respondent. The parties had lived together for 13 years and, in fact, had 2 children together. In this situation, the mother of the children and the de facto wife sought a property financial settlement upon the breakdown of their relationship. Their relationship was after 2009, so that was not an issue for the court to determine. However, the father and the de facto husband says the relationship was an association of convenience, and he just lived with the de facto wife so that he could help the children. He denied any existence of the relationship. In this case, the court was asked to consider that and determine whether there was in fact a de facto relationship. And I won't bore you with all the background details, but ultimately in that case, the court was quite critical of the respondent in that situation, and the assertion by the respondent of not living in a de facto relationship but rather having an association with the de facto wife because they were raising these children together. And the fact that the respondent asserted that he just had sex with and lived with her was unsustainable for the court, and on that basis the court determined that there was a de facto relationship. They determined that the de facto relationship was for some 13 years as asserted by the applicant. The respondent de facto husband was criticised for the conduct of his case further, showing that he was devoid of personal affection and regard for the applicant, viewing that he had treated her more as a flatmate and whom he had sex with for convenience. In that regard, the court, when looking at the relationship and considering what adjustments should be had and looking at the future needs, which I'll talk about, which is a step that the court needs to consider, and I'll talk about a bit further into this webinar, The court actually gave a small adjustment in favour of the applicant just on the basis of this, what they termed her greater contribution to the relationship and the difficulties she would have overcome in that relationship because of the respondent saying they weren't in a relationship and treating her as a flatmate. I've put some further cases and a couple more recent cases which you're welcome to look up. They can be found on the OSLI website, or if you do want links to those cases, I can certainly provide them as well. Please just send me an email following the webinar and you can look, and I will send those through. I have no issue with doing that. One question that we are often asked by clients is, what is separation? And I think this is quite a difficult idea because we don't live in a black and white world. Separation can just be a mere communicated intent to another party. So saying to your partner that you no longer wish to be in a relationship can be deemed as a separation. Separation and the date of separation is only relevant when we consider time limitation. And I will talk about time limitations following this, but time limitation is quite important in regards to de facto relationships, as there are strict guidelines about that. Separation can occur physically, so one party moving out of the home or the shared residence or no longer spending those nights with each other, but separation can also occur under one roof, and it's not uncommon, especially when assets are tied together or there are children involved, that parties do separate and live under one roof together, and that may continue right until there is a final property and financial settlement. Time limitations concerning de facto relationships are quite important. To seek a property and financial settlement, if it's not otherwise agreed, you need to do so within 2 years from your date of separation. That's why diarising when you separate is important, and having regard to that date and when you seek legal advice is also important. If you didn't seek relief from the court, so if you didn't commence court proceedings or file documents which show that you've reached agreement about your property and financial settlement within that 2-year time frame, you'll then need to go to the extra expense and really extra step of seeking for the court to approve you to seek that property or financial settlement from the other party. We term it as leave. So you're asking the court to grant you leave to proceed with an action. This can be difficult because you need to show to the court that there is going to be hardship that would be caused to you or a child if that leave wasn't granted, or for maintenance applications, that the party's circumstances are such that at the end of that time he or she would be unable to support him or herself without an income-tested pension, benefit or allowance. So it's very important that dates are diarised, that legal advice is sought, ideally following separation, and if that hasn't occurred, as when they can seek legal advice, but before that 2-year time limitation expires. As I noted, if you have to seek the leave to proceed out of time, you have to satisfy the court that there would be that exemption that needs to apply, so that hardship that would follow. And this can be costly and be quite complicated and time consuming, and really something that should be avoided. When it comes to children and de facto couples, it's exactly the same as married couples, so there is no distinction. Because the Family Law Act focuses on children's rights and not parents' rights, it doesn't matter if their parents were in a de facto relationship or a married relationship. best interests of the children are paramount, and that's provided for in the legislation. I've put the references there in case anyone's inclined to go and look at the Family Law Act. But when the court does consider parenting applications, there's two primary considerations when they assess best interests for a child, and they are the benefit of a child having a meaningful relationship with both parents and the need to protect the child from physical or psychological harm, from being subjected to or exposed to abuse, neglect, or family violence. There are circumstances and cases when the second primary consideration, so that the need to protect the child, takes precedence over the first. There's cases where it's not always appropriate for a child to have a relationship and spend time with a parent. Spouse maintenance is something that is now available to separated de facto couples that previously wasn't available. This is a relief that can be sought, and there are provisions for it under the Family Law Act. Spouse maintenance is a payment or a income that goes to the other spouse after separation and after a property financial settlement. We have the same rights. De facto couples have the same rights as married couples, and the test is whether there are low income, so there's a shortfall, and the other party has a surplus, so a capacity, and it's an assessment as to whether there could be a spouse maintenance payment made to one party. Typically, these types of spouse maintenance orders had not been favoured by the court, as the court wants parties to have a clean break when they're finally dividing their property and financial interests, and that's called the clean break principle. Spouse maintenance has come about more commonly these days because of smaller pools. So with financial crises and parties separating, it has meant that the pools have been quite small, and perhaps there was nothing or a negative pool in which to divide between the parties, but one party did have a disposable income that could be accessed. And in those circumstances, the court has made orders for there to be spouse maintenance. When seeking spouse maintenance, the onus is on the applicant, so the low income earner, to seek this from the other party. They also have an obligation to mitigate his or her own living expenses and an obligation to seek employment. So it's not the case that they can simply say that they have no money or they earn little to no money and seek for that to be paid for from the other party. Usually, if a court will make a spouse maintenance order, and especially on a final basis, they'll indicate that it's for a set purpose, and that might be the need for maintenance to arise because a child has a physical or a mental incapacity, or if one of the parties is undertaking some retraining so that they can then get gainful employment, or if they can't return to full-time work because they're caring for a child who's particularly young and doesn't allow for them to return to full-time work. I want to now talk to you about property and what it is. I think this is probably the most relevant part of my webinar when you're speaking with your clients. Property is really how we suggest that people should think about property is that it's defined very broadly in the Family Law Act. Property includes real property, personal property, chooses in action, and goodwill. So typical examples of property include real property, so the house, motor vehicles, boats, shares in public companies, shares in private companies, jewellery, furniture, bank accounts, and superannuation. There is no distinction between personal assets and business assets. It does not matter if the property is in one party's name or the other, or in a business name. It's necessary as part what the court asks you to do, to examine the nature of an interest in more detail to determine whether it's property or what we also call as a financial resource. And a good example of a financial resource might be a pension stream, annuity, or a trust if you're a beneficiary of a trust. I think it's also relevant at this time to dispel some of the myths and also talk about people seem to have this conception that if it's not in their name, it's not their property. As I've said, property is very broad. Just for the fact that it's in a business name does not mean that it's not deemed property between parties. There are some items which would not be termed as property, and these might be choosers in action. In terms of a right to sue is not deemed as property, or if there's a non-transferable item, a mere hope or an expectancy is not property, and a capacity to borrow money is not property. But otherwise, most other things come under the umbrella of being deemed as property. Family Law Act also provides that proceedings are in personam and not in rem. So orders can be made requiring a party to deal with property regardless of where the property is located in the world. In personam meaning in person. Enforcement of those orders is a separate and more difficult issue and something that we do encounter. But certainly the mere fact that it's in your name means that it is something that you need to tell your solicitor about, and it will be deemed as property. There is an idea about notional property and the division of assets and liabilities and resources where notional property is added in. The most common situation of notional property and what we term as an add back is for legal costs, because that's not normally treated as a liability. But that's more of a rarity than notional property and less favoured these days. There is only one means of protection that you can talk to your clients about before or during a relationship. So if your clients are wanting to avoid any litigation upon the breakdown of a relationship, they do have the option, assuming the other party agrees, to enter into a financial agreement before or during that relationship. So similar to prenups, which is of course talking about people who are about to marry, you can do a similar sort of agreement for de facto couples where you enter into a financial agreement that says what will happen upon the breakdown of your relationship. You can also do that once you've been in the relationship for a period, and you might decide to do that especially if you're involved in a family business or a trust structure and there's a period of asset acquisition that you're wanting to protect. Certainly something that your clients may be interested to know about. If you don't have a financial agreement, however, upon the breakdown of the relationship, if that party is seeking a property and financial settlement, you won't have anything to rely upon to say that certain assets are excluded. One of the first steps that a court, if a matter is to be litigated, and certainly when we give advice, we undertake is to identify the property. So going through what I discussed before and identifying each asset and liability, including superannuation. We then need to value that property and consider what value should be attached to that property. When looking at the value of a property, it's important that you consider that it's always current value. So it's not the value as at separation. And that's something that people are always a little bit concerned about. There are reasons why doing a property settlement soon after separation is better, or perhaps even waiting a period of time can be better. Those current valuations are always used. Any market gains or market forces are then felt by both parties, given that current values are used. We then look at, as what we term steps 2 and 3, at contributions. So contributions are taken into account and include financial, non-financial, homemaker and or parent contributions. So financial contributions considers contributions wide and what each of you owned and owed when you moved in together, as well as any gifts or inheritances received during the relationship. The non-financial contributions are what each person has contributed to the conservation, preservation or improvement of any assets. For example, renovating a jointly owned property is usually one of the most common non-financial contributions. Some of the less common ones are if grandparents have been involved in the care of a child, or particularly fly-in, fly-out employees, if there's been really just one constant parent staying at home to be the homemaker and parent, those non-financial contributions are of course considered. There are also homemaker and parenting contributions that are looked at and considered whether those domestic duties have been shared. All contributions need to be evaluated in the context of other factors about that relationship, and they're considering the length of the relationship and the future needs of the parties going forward. When I say future needs, what I mean is the need to look ahead and take into consideration the factors affecting the future needs of both spouses. There's a wide range of factors that the court considers at this stage, and some of them are other age and health of the parties, whether one party earns a higher income than the other, whether there's a party who has the care of a child or children of the relationship, and they're all weighted against each other. The last step that the court will undertake is considering, is that just and equitable, and whether there should be an adjustment in that regard. Certainly, those adjustments we always talk about are in percentages, and we always suggest that parties need to get advice about what sort of entitlement the other party may require, as it changes in each situation. So often we hear, well, my neighbour got 70% of the pool and I was at home at the same time she was, so I should get 70% of the pool. Or they've been talking around the lunchroom and saying, well, I had to pay my wife $40,000 and he was married for 10 years, I was married for 12, so does that mean I just have to pay $50,000? These are misconceptions. There's no set formula. Each relationship and contributions are going to be different to the other matters, and they'll be weighted differently. So it is the case that you should be strongly encouraging your clients before having any settlement negotiations with the other party to go off and get some legal advice about it and specific to their situation. We'll also be able to assist them with understanding how that sort of division can come about as well, because of course certain assets cannot be split or would need to be sold, and we can talk about that. I did just want to pose a polling question at this time. I think I've touched on it before when I said about current value of an asset. I just wondered, do you think your clients would be surprised to know that? Certainly we encounter clients who are quite shocked that figures aren't as at the date of separation, and that their current values and that all assets are included in the pool, including, it seems to be, superannuation is a sticking point for a lot of people. And I will talk about superannuation next, but I am interested to know whether you think clients would be surprised about that. Well, I definitely got an emphatic yes on that polling question. We usually, as I said, we usually encounter a bit of a shock and awe from our clients when we recommend it. all I can say in that regard is full and frank disclosure. Both parties are required to make it of their financial circumstances. And current values are subject to those market forces. So there are some matters where getting settlement done soon after separation is so very important, especially clients which you're interacting with who may have business assets that they're purchasing, or they're looking at purchasing other assets or consolidating superannuation, or about to come into some sort of financial windfall. There could be benefit in resolving matters sooner rather than later. Superannuation in regards to the Family Law Act, and certainly married couples, has existed since 2002. With de facto couples coming to be under the umbrella of Family Law Act in 2009, this has meant that superannuation is also treated as property for de facto couples. A misconception, though, out there is that there is no requirement that superannuation be split between the parties. The court always retains a discretion if it is to be split or if it is not to be split, and certainly if it needs to be split equally. But in saying that, often superannuation is one of those assets that we can split quite easily, and certainly in a pool that's available for division that has little liquid assets, superannuation is an asset that can be split and is sometimes favoured. If the split, there's no set formula to assess how much or the proportions of any split, and there's no assessment on when it should happen and when it doesn't need to happen. So it is something that parties need to be considered of. In terms of any superannuation splits, they can be allocated a base amount, or it can be a percentage amount, and that superannuation is then rolled over into the non-member spouse, so that they then have a interest in that superannuation fund, and if they seek to have it released, they would need to meet with the superannuation fund's requirements through their trustee rules in that regard. Property, if you can agree and if your lawyer can assist you to agree, they can sign documents to formalise it. And that's probably one of the biggest take-home points that I want to emphasise today, is the importance of formalising any agreement in relation to division. We often encounter couples who say, but we had an informal agreement, or he promised, or we were going to deal with it when the children were a bit older. If you don't formalise it at the time, you are relying upon the other party upholding that agreement. And as we know, circumstances change for people. People enter new relationships. There are things that happen that would make someone maybe not honour an agreement that they've previously agreed to. So it's important that it is formalised. There's two ways that you can formalise it. One is to do a consent order, and that can be both property and children, and the other is a binding financial agreement, and they both have their benefits in that regard. The last polling question of the day, and I do appreciate everyone participating, is, are you aware of clients, or do you encounter clients who say they've separated but haven't legally formalised their property or financial settlement? They're very much at risk, or there is an exposure to them. So certainly you should be telling your clients to go and get some advice about that, even if it's after the fact, just so that we can talk about ways that they could maybe minimise that exposure and risk. So the poll questions, the answers here are showing that everyone's agreeing that they are certainly encountering those clients. Some of the benefits that you might like to talk to your clients It's about why they should formalise the agreement and why they should go off and see a lawyer. I know that there's some reluctance to see lawyers out there, but some of the reasons that you might suggest it is the finality. It really does draw that line in the sand. And although we can't guarantee it's 100%, what we do endeavour to ensure is that there is no methods that the other party can then agitate or seek a property or financial settlement at a later point. It also provides and has benefits in relation to capital gains tax, rollover relief, and stamp duty concessions, and it's the only way that you can deal with the superannuation interest. So only if it's formalised through a binding financial agreement and consent order can superannuation interests be split. Hopefully I've given you a bit of information about property and how it's determined and what would be deemed as property so that you can inform your clients. Some other little things that I wanted to touch upon are some considerations that you should be talking to your clients of, and certainly we're always thinking about. Some of those are amending their will, revoking any powers of attorney, whether it's necessary to sever any joint tenancy on any real property, the benefit of staying in the house and retaining some of the furniture and chattels, how to limit liability, so looking at the mortgage and credit cards, looking at whether there's a redraw facility on the mortgage and whether there needs to be a joint authority, whether the other party has a secondary credit card or whether they could increase levels on credit cards, and also how you would access funds. And that's relevant for the party who's seeking to separate and perhaps finds themselves in the situation where they've been told the relationship is at an end, looking at where will they access funds from to continue living until there is a property or financial settlement. I have set out what we term as our tips to try and assist and talk to your clients about some ideas. Keeping a diary, as I noted, time limitation dates are quite important, so keeping a diary about relevant matters, financial matters, is a good tip. Making a budget, so if you are going to agitate for any spousal maintenance, having an idea of what you're spending your money on is going to assist. Collecting documents. In that regard, it's about collating your financial documents. So before you separate or following separation, to comply with those full and frank disclosure obligations, collating your financial documents is important, especially if you think that the other side perhaps maybe are not going to provide their full and frank disclosure, or you think that they might try and attempt to hide a financial asset. Collating documents, taking copies of them, certainly the lawyer can then talk to you about what efforts can be made to ensure that that is included in the pool. Consider whether you need to put in place a caveat or an injunction, so that's really stopping a party from selling a property, or whether there needs to be injunctions secured from the court in relation to the disposal of assets or removal from a company or a trust. Consulting a financial advisor, and also having sufficient life insurance for yourself. It's all about getting a plan. We find that our clients who come and see us early on and have a clear way forward are better prepared for the process, but also feel more comforted by the process because they've got a plan. Some of the traps, and I've touched upon these already, don't delay in the property settlement. I think that is one of the things that we see. People miss the limitation date, or they've delayed. There was an agreement and now the other party's not agreeing, or assets have actually been encumbered so that there's little to no equity. Not delaying will avoid that. Documenting an agreement correctly. I touched upon that earlier. The formalising of that agreement is also very important. It does draw that line in sand. It gives the protection that your client's needing really to then move forward with their life. Using correct asset values, so working out, not just giving estimates, sometimes getting a valuation and spending that money to get a valuation is well worth it. not negotiating under pressure. I think parties think, I want to avoid court, I'll do anything to avoid court, and therefore agree to things that maybe then they wouldn't necessarily agree. Taking the time, making a considered approach, it all comes back to that, get a plan, and not negotiating under pressure is something that your clients need to think about. So that's the webinar done. My mouth is very dry from talking for so long. Thank you for listening. Thank you for giving up your time. If you do want to know more, I invite you to contact me. I will put up my contact details, or invite you to contact our firm. If you are inclined to listen to another webinar and give up an hour of your time, we're always interested in hearing topics that people are wanting to be spoken to about. We can also come to your firm and give a more in-depth presentation. I do just need to give a plug for a colleague. She's doing a webinar tomorrow, and it's called Counsellors, Courts and Confidentiality. It's happening between 2 and 3 o'clock tomorrow, and if you're interested, you can certainly register on the email address provided. Lastly, contact details. So we're located in North Quay. Our phone number is 3221 4300, and I will also put up our email and website address details, and send out material contained in this presentation will be sent out by a link. I'll also be sending out, I'm getting a note here that there'll be a feedback survey. Please be kind. My managing partner will look at this, so we appreciate the feedback. This is my first webinar. I hope you've enjoyed listening to it. And as I said, I invite you to contact me. You can address any emails to me, and I'll certainly come back to you. Thank you.